joined, so let's get going.
Okay.
Thank you for being the first one in. We've got federal judges busy as beavers over the long weekend, some holding hearings on Sunday and Monday, issuing orders against the Trump administration, some working to polish and fine-tune their 52-page rulings that the Trump administration has violated the Posse Comitatus Act. The first time in U.S. history a federal judge has made that declaration. That's always been a touchstone. It's always been seen as inviolable, sacrosanct to protect the American people from an out-of-control president using the weight and might of the U.S. military against its own citizens on domestic soil. We talk about it just that way. And yet when Donald Trump saw it, it was a little fly that he could just swat away as he nationalized the Guard in California, took it over, demanded or just defied orders related to it, and then went further. And Judge Breyer, and we have Adam Klasfeld and the audience from All Rise News here joining the Legal AF audience here for this update. We knew that, that this day was coming because, Adam, you covered the 3-day trial.
Right.
And for those that are just waiting for a few more people to join, the headline is easy. Judge Breyer, San Francisco, declares that the Trump administration has already violated the Posse Comitatus Act by using Marines and other military forces as an occupying force in California, and has ordered them to stop doing it, stop violating the law. And he has stayed his order until the 12th of September to give it time to kind of filter back up to the Ninth Circuit Court of Appeals and ultimately to the United States Supreme Court. But I don't want anything to be lost here. Not only has a federal judge declared for the first time in our history, and has had to declare because of the rogue behavior of a president, that this president has violated the Posse Comitatus Act by using those troops against American citizens and others on U.S. soil, and having found the evidence to do that. But he has also gone a step further and said, I, as a federal judge, in providing this oversight, pardon me for everybody, can block by way of injunction, declare that it's been violated. I don't have to just rely on fines and crimes, which is how the statute is organized. So, Adam, why don't you give the big headline of what the judge is most concerned about in this new ruling? And of course, this will be posted today on Legal AF Substack for everybody to read. Go ahead, Adam.
Right. Well, you hit the nail on the head about the headline. That he put it. This is a very short sentence that said it's exactly what you said. In short, defendants violated the Posse Comitatus Act. This is Newsom v. Trump. So he said Trump has violated the Posse Comitatus Act. And he said that the Trump administration has systematically used armed soldiers whose identity was often obscured by protective armor and military vehicles set up protective perimeters and traffic blockades, engage in crowd control, and otherwise demonstrate a military presence in and around Los Angeles. So it doesn't get much clearer than that when he says just point blank, defendants violated the Posse Comitatus Act. So what comes next? You had mentioned how Judge Breyer used the phrase national police force, noting that the plans of the Trump administration is to expand this to other California cities and other U.S. cities. But the ruling that he gave was very narrow. His order essentially orders the Trump administration to stop violating the law, stop violating the Posse Comitatus Act. He does not order the Trump administration to remove the 300 troops that are now on the ground in Los Angeles through November.
Let's stop right there. So the original surge that went into California, as noted by the record, and you listened to the evidence, was larger than what we used in Afghanistan after 9/11. What's remaining is about 300, still to this day, despite the fact that there is no insurrection, there's no rebellion, there's no riots on the streets of California. at all. Yet Donald
Right.
Trump continues to maintain an occupying force of 300 and uses that as a blueprint. Because right when this trial, the first day of this trial, that is the basis for this order, was the day they had a press conference and announced they were going to take over the District of Columbia and occupy that. Now, that's slightly different because of the relationship between the federal government, the president, and the federal district and what he can get away with. However, he's threatened now to take this show on the road, this illegal Posse Comitatus violating show, to other blue cities and states near you, like Chicago, like Philadelphia. And this was a shot across the bow, wasn't it, Adam, by Judge Breyer about Donald Trump's desires to crush opposition illegally and unconstitutionally through the creation of effectively a federal police force.
Absolutely. And he uses a phrase, a national police force, with the president as its chief. I'll read the exact line here that Trump and Secretary Hegseth have stated their intention to call National Guard troops into federal service in other cities across the country, including Oakland and San Francisco, here in the Northern District of California, where he wrote this opinion, thus creating a national police force with the president as its chief. So he sees where the wind is blowing here. And it's a shot across the bow in that he says now that the Ninth Circuit has limited his power, he can't tell the Trump administration, remove the troops from the ground, but he can tell them, under the Posse Comitatus Act, they are not allowed to engage in civilian law enforcement. So if you want to have them standing around outside a federal building, he doesn't have the power to call that off. But as a blueprint, what Trump is talking about and what he has talked about in press conference after press conference is using them as a crime fighting force. That's what they cannot do under the Posse Comitatus Act. That's what they have not been able to do since shortly after the Civil War. That no president has tried to use the Posse Comitatus Act for that purpose. And that's what he has found the Trump administration did. And so to talk about, again, I mentioned this a little bit earlier, this is a very narrow ruling because he understands this is going right back up to the Ninth Circuit. He does not order the troops out of California. He does not order, and they are currently there, slated to be there through November, through Election Day. He does not say you cannot send the troops to Chicago or Baltimore. It is silent on what is going on in Washington, D.C. He is essentially saying you must follow the law. And the entire crux of the defense here of the Trump administration was that, oh, there's an exception. There's a so-called constitutional exception to the Posse Comitatus Act that lets us use the military for traffic blockades, crowd control, if there's some tie to federal law enforcement and federal law enforcement building. That's nonsense, Judge Breyer says. And he shows the training materials used by the Task Force 51, which is the commanding force of these troops. And he says that the training materials, insofar as they say there are these exceptions, that's wrong. And that's a violation of the law. And that's what his order blocks.
Well, let me give you from my perspective. It's narrow, but it is historic and groundbreaking in a number of different ways, and I don't want to lose sight of that. It
Right.
has to be narrow because of the Supreme Court ruling in May that took away the right generally for federal judges at the trial court level to issue nationwide injunctions and to block more than what is directly in front of him. So, of course, it was always going to be a California centric, but he's speaking to multiple audiences here, including to the United States Supreme Court, where his brother, Stephen Breyer, was a Supreme Court justice, now retired. And he's also speaking to the Ninth Circuit. And it's not just a genuflecting to the Ninth Circuit, like, oh, you were so good when you reversed me and so clear in your ruling. It's so easy for me now to make my ruling about Posse Comitatus Act. Oh, no. In there, he has barely veiled I won't say it's dripping with sarcasm, but he comes right out of the box and says, let me translate it. I can't make head or tails of your decision. I got the crux that the commandeering of the National Guard you found was okay. And you don't want federal judges questioning when a president declares a rebellion or when he can't enforce laws. However, you left open lots of different things that I am now forced to address. So there's a moment where he schools the Ninth Circuit, at least the three judges of the Ninth Circuit, right?
Right. I think that in the very first paragraph, he says that there was no rebellion nor civil law enforcement unable to respond to protests and enforce the law. And that's a direct rebuke to the Ninth Circuit.
Right.
I think in a certain sense, the evidence had come in at trial. The Ninth Circuit had not seen the evidence. He was making a fact-finding decision at that
That's right.
moment. But he said that the basis of the Ninth Circuit decision was essentially that it's at least plausible that civilian law enforcement was unable to respond, and therefore he must be
Yeah.
allowed to do this.
Well,
And that's a rebuke to that.
Yeah, while we're here, we'll take a quick 1 minute ad break for the Legal AF Substack and All Rise Substack. If you go to this little chyron at the top, this little capsule, and you press it, you'll learn if you are a subscriber to one or both. Now's the time to show your support for what we do, for the content that we create for you, the velocity at which we create it. If you want to be a supporter of what we do here on Legal AF, where Adam Classfeld is a major contributor, and on his own his All Rise Substack, then hit that button and subscribe. And if you can go further and become a paid member, that's what sort of keeps the lights on and pays the bills, and we appreciate that as well. Let me read to you in our audience, Adam, from what I refer to as the Ninth Circuit critique section of Judge Breyer's order. These are his bosses, but listen, he's a senior status judge for a reason. And he faults the Ninth Circuit, finds a way to thread the needle to come out the other end with his ruling that there's been a Posse Comitatus Act violation by the judge. And for those that are joining late, we have this historic ruling by Judge Breyer that there's been a violation by Trump, the Department of Defense, and others of the Posse Comitatus Act. And then he does something about it in the form of a declaration and an injunction. That's another reason to subscribe. You'll pick up this video. Once we're done, it'll post. And if you're a member, you'll be able to get access to it and know what the heck we've been talking about for the last 15 minutes if you're coming in late. But here's the Ninth Circuit critique. So on page 27, 28, and 29 of the 52-page order, Judge Breyer writes, the impact of defendant's argument, that's Trump's side, is largely due to the Ninth Circuit's reading of the Posse Comitatus Act, staying this court's temporary restraining order pending appeal. In that order, the Ninth Circuit held that courts can review the president's invocation of the act only to determine if it has a colorable basis and if it is made in good faith. The Ninth Circuit did not clarify these standards further. For example, it did not explain how a plaintiff could challenge or how a district court could evaluate, especially on an expedited basis, in proceedings for preliminary injunctive relief, a violation of the Posse Comitatus Act for a lack of colorable basis or good faith. Nor does the Ninth Circuit suggest, I keep saying Posse Comitatus Act, 12406, let me reverse course here. If I was recording this for YouTube, I'd edit this out. Well, everything I just said was true, except he was referring to the statute allowing for the commandeering of federal troops. So he's critiquing the ruling by the Ninth Circuit, not about Posse Comitatus. Sorry, my eyes slipped on the reference. But this is, look at this example on page 28, Adam. The Ninth Circuit also suggested that the president can invoke the statute to commandeer the National Guard if its ability to execute federal law has been significantly impeded. This is a whole section he does not have to write about how he lost and how murky the decision was and how federal judges are left in the lurch. So he does not have to write this to make his Posse Comitatus Act. But listen to this, because this is scary.
I know where
he
you're
says,
going.
thus, under the Ninth Circuit's test, the president could federalize the National Guard in any number of cases. One, the president, relying upon IRS data showing that a sizable percentage of corporations and individuals are using tax shelters to avoid paying taxes, could claim that he's unable to execute the tax laws and federalize the National Guard. The president, relying upon EPA studies, environmental protection studies, showing pollution in a river cannot be traced to a specific plant, could claim he can't execute the Clean Water Act. Well, we know this president would never do that because he doesn't abide by the Clean Water Act. The president, relying upon health data about a narcotic-related symptoms, could claim that he is unable to execute federal drug laws. A president, now here is a shot at both the Ninth Circuit and Trump. The president, relying upon anecdotes from state election officials that voting machines are glitching or that fraud exists, God, who does that sound like? Could claim that he's unable to execute the election laws and send it. And so this apocalyptic vision, this is the section that I love the most because it's completely unnecessary, but it's Charles Breyer telling the Ninth Circuit, his bosses, you got it wrong. And the way you wrote it, look at the can of worms that you have opened, the Pandora's box that you have opened.
Right.
And now you got to let me make the Posse Comitatus Act ruling. Sort of like, you can't take that away from me. You already effed this up.
And
right?
as I was listening to you read that section, Michael, it reminded me of something that was a common thread, probably the most repeated line from Judge Breyer in both before he issued the TRO and during this 3-day trial were, what are the limits? And he is absolutely disturbed by it. He keeps asking, what are the limits? Because when this goes up on appeal, and yes, it will go up on appeal, he has stayed his ruling until September 12th, so the Trump administration can fight it. He has practically dared the Ninth Circuit. He has said, look at that he has laid out the battle lines as, is the Posse Comitatus Act good law? If you are going to overrule this, then it's a nullity. It doesn't exist. It is basically saying you need to follow the law. What is there to overrule here? And he did. You laid out those hypotheticals. He says a little bit later after that, in doing so, they make plain the consequences of the Ninth Circuit's highly deferential reading of the statute. That it is so deferential that there's this removal of any seeming limitation. And when I mentioned that this is a narrow ruling, I don't mean to diminish at all. And you're right to note its historic significance, its historic weight at this moment in our history that we find ourselves. This is in some ways a roadmap to navigating these legal issues when Trump pushes the envelope next time, when it comes to a different federal court. This is going to be the way these legal issues are read, and it is saying to the Trump administration, if you want to send troops to stand around federal buildings, well, my hands are tied. The Ninth Circuit won't let me tell them to go away. But this law is law. Here's the history of this law. Here's what the founders feared with the emergence of a national police force. Here's what the people who wrote this law and passed this law thought, both good and bad. In the shadow of the Civil War. And we're not going to interpret this law out of existence under this highly deferential standard.
Well, let's talk about that. Let's do a tabletop exercise. For those that are joining, you've got a combination of Legal AF Substack and Adam Classfeld All Rise News coming together here. Take a minute, hit that button, find out whether you're subscribing to either or both. Subscribe to both. And then that'll give you access to this video, which this analysis, it's been going on for now about 15, 20 minutes. You'll get the video if you become a subscriber, and think about becoming a paid subscriber. So what the tabletop exercise is the Supreme Court ruling somehow that the Posse Comitatus Act on the books since 1878 is an improper infringement on the president's Article 2 powers as commander-in-chief or otherwise, or for national security or whatever. Let's get there in a second. The things that the judge pointed out that some people might be asking, well, what'd they do? What was so bad about the Marines on the ground in California or soon to be Chicago or other places? And it has to do with what even in their own training says they cannot do, where they're being used as local law enforcement. We've seen it in DC, picking up the trash, moving people out of homeless encampments. It's security patrols, not allowed, traffic control, not allowed, crowd control, certainly not allowed, and riot control. And the evidence shows they violated all of those while they're in California, that there was no proper guidance, there was no even an attempt to walk this very narrow path to both having proper federalized National Guard and other people on the ground in California, but not violate the Posse Comitatus Act. But when it gets, because the Supreme Court has been on the sidelines up until now, to have them weighed in, nobody's asked them to weigh in. Well, they're going to weigh in. We got a court where at least 5, if not 6, of its members on the right wing think that a unitary president model applies, meaning there is a one occupant for that branch of government as opposed to the other branches. That person's name is the president, even though it mentions officers and people in its administration within the Constitution. He has alone the omnipotent power in that branch, and no attempts by the other branches can, even though there's supposed to be checks and balances, there's supposed to be there's supposed to be ways for friction to occur to rein in an out of control branch. You can just see the Supreme Court saying that Congress in 1878 got it wrong, and it's our first opportunity to right that wrong and declare that this impedes on the power of the presidency. Congress can't take away his right to use military as law enforcement, right?
Right. Well, you had this kind of different dance of the public relations version of the White House on this, where you have Trump going and saying, we're going to use this for civilian law enforcement. And then they come into court and say, oh, we're not using it for civilian law enforcement. We're invoking a constitutional exception. And there's an incredible thing on page 7. The judge lays out a slide from their own training. Task Force 51 commands the troops who are in LA right now, and they receive this training on the Posse Comitatus Act. And there is a bullet pointed list, about a dozen bullet points. 4 of them are in red. Those are security patrols, traffic control, crowd control, and riot control. And they're in red because under the theory to the top of the Department of Defense, Pete Hegseth, they're claiming there are constitutional exceptions to when they can do this. The judge said no, absolutely rejected that. And that's one of the bases for this ruling. But it's a very telling moment when the evidence came in, when it came out in court, because it shows they are aware that under most circumstances, they are not allowed to do this. They're coming up with a new legal theory, which the judge notes was never even part of the Department of Defense's legal theory. It was something that was manufactured after the fact. But it goes to show that when the chips are down and they're coming to court and they're defending this, they're coming up with all sorts of excuses why the Posse Comitatus Act doesn't apply, either because there's a constitutional exception that they invented, which, as you noted, Michael, is their executive power. And in this particular case, it gets a little bit more in the weeds as to if they're protecting federal law enforcement or a federal building. But they come up with other excuses, like this is a criminal statute, and a judge can't enforce this. Well, if it's a criminal statute, they refer it to Pam Bondi's Justice Department, or if the person violating it is the President of the United States, he has immunity. How is it enforced? And so there's an interpretation of this that comes out to any way you interpret this, we, the Trump administration, win. And that is the interpretation that was rejected by the judge. You can't define this centuries-old statute out of existence.
Yeah. Yeah, so that's excellent points, and you see where the Supreme Court's going to have to get involved. Next stop on the train is going to be the appeal by the Trump administration back to the Ninth Circuit, likely assigned to the same three judges, one Trump, one Bush, one Biden, that ruled against Judge Breyer before on the commandeering of the National Guard, which, as I said before, you'll read it for yourself when I post it on Legal AF Substack. He spends he spills a lot of ink and a lot of tea going after the ruling against him and telling them why they're wrong, but which I think is a little bit of a series of body blows to soften them up for ruling in his favor on the Posse Comitatus Act, because we'll end this live the way we started it, or the way you've always started it, Adam, having watched the trials. It's what are the limits? I mean, you can't come if you hear him bemoan as a judge, and this was a trial. This is a trial verdict. This is a judgment, even though it's listed as an opinion. And he said frequently during the trial, but what are the limits? You can't come to my court and tell me, A, I don't have the power to do oversight. B, I can't create a remedy, and that there are no limits. It is whatever the president says it is in our constitutional republic. That can't be your position, although obviously that was Donald Trump's position. So it'll go up to the three-judge panel. Maybe somebody will ask for, or it will happen that it will be ultimately an en banc decision, an en banc request, which means all 20 plus judges, with the majority winning on this very important issue. I think it starts with the original three judges, and we'll follow that here closely on Legal AF Substack Live and on Legal AF YouTube. And then it will end up dumped in the lap of the Supreme Court, whether they want it or not. Likely when the new term opens the first Monday in October. Got a lot of new rulings that we're following here on Legal AF and on All Rise News. We just had a ruling over the weekend. A federal judge, Judge Sparkle Supnanan, issued 15 orders in less than 24 hours against the Trump administration to get 76 minor children unaccompanied off a plane who were about to be deported at 1 o'clock in the morning without due process, in violation of their rights as participants in the Refugee Resettlement Act, and being sent in the middle of the night or early wee hours of the morning, which is where Donald Trump does all of his dirty work, until a national immigration rights group filed an emergency injunction, which landed on a judge's desk at 2 o'clock in the morning and 3 o'clock in the morning, and we're off and running. The good news is Sparkle Supnanan, the judge, a Biden appointee, who used to be a very high official in the Department of Justice in the Civil Rights Division, and also had clerked for Justice Sotomayor. After 15 orders, she got those 76 kids off the plane. And the class that she's protecting is over 600. That was on Labor Day Sunday over to Labor Day Monday. This is a ruling that's coming out on Labor Day Monday +1 by Judge Breyer. These are very fast-moving stories, and the best place to follow it is here on Legal AF Substack Live, along with Adam Klasfeld at All Rise News, and on Legal AF, the YouTube channel. You may have read a lot about Adam Klasfeld. You may have read a lot of his work, but now you're seeing him in the flesh on a regular basis, at least once a day over on Legal AF YouTube, and we really appreciate you being here with us and for us, Adam.
Thank you, Michael. Always a pleasure. It's great kind of getting into the really important details of the stories that are shaping where we are today.
2,000 people decided to stop what they were doing and join us from the bottom of our hearts. We appreciate you. Take a minute. You can show your appreciation. You can hit the subscribe button for both Legal AF YouTube and Legal AF YouTube. No, Substack for Legal AF. Forgot where I was for a minute. And Adam Klasfeld's All Rise News. And if you can swing a annual subscription or a monthly subscription, that's the way you can really help us keep the lights on, get Adam back into those courtrooms, keep our contributors moving and grooving on all the channels. So I really appreciate all of you. Till our next time together, Michael Popok and Adam Klasfeld.